think I started this trial off by telling you that all she had to do was ask for a ride. And I'm going to continue to say that. Now, there's been a lot of proof put on, or some proof put on, by the defense and through witnesses of the state, that they didn't see obvious signs of impairment from Ms. Hinds on that night. That really wasn't their primary concern, but certainly if they would have seen it, they would have said something about it, or done something about it, given her a ride. It is not their duty to babysit the defendant. Just like Tracy Phillips said, it's not their duty to babysit the defendant. They're out there having a good time. It's busy. There are a lot of people there. The band is playing. That is not their primary concern. The person who should be worried about that, the person who should be focused on that, is Janet Hinds. It's the defendant. She's the only one that can say for certain whether or not she's impaired. She's the only one that knew how much she had had to drink. The rest of those individuals did not. They had no idea. They thought she had had, one of them thought that she had had one beer, Ms. Phillips. Melissa Hinds thought, well, because she could only associate her with 2 beers. It's her responsibility, not theirs. It's her duty to make sure she's okay to drive. And she didn't do that. She didn't do that. She should have realized that 5 drinks, 76 ounces of beer, over a 6-pack of beer, and a shot of alcohol is too much to drink when you're about to drive. That's too much. She should have taken it upon herself to make the appropriate decision and not drive. She didn't have to. It's her responsibility, not anyone else's. They are not there to babysit her. They are not there to make sure she does the right thing. She has to do it, and she didn't. Now, it's clear from the proof that the state has proven beyond a reasonable doubt all of the charges, all of the elements associated with the charges in this case. It is clear the state has proven beyond a reasonable doubt that she was driving under the influence, that she failed to maintain her lane, that she did not exercise due care when she was out on the road, that she was speeding, that she violated a traffic control device. It's clear that she failed to render aid. It's clear that she failed to report an accident. It's clear from the proof and beyond a reasonable doubt that she left the scene of that accident when she reasonably have known that it resulted in death. It's clear she committed reckless driving, and the state has proven beyond a reasonable doubt that she committed the offense of vehicular homicide by intoxication. Now, that is 10 separate charges that the state has proven beyond a reasonable doubt. I want to talk about 2 of those. I want to talk about leaving the scene of an accident involving death. And this is the charge that you will get. The judge will instruct you on it. Any person who commits the offense of leaving the scene of an accident resulting in death is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant drove a vehicle involved in an accident resulting in the death of a person. Yes. That the defendant failed to stop such vehicle at the scene of an accident or as close thereto as possible, and then forthwith return in every event remain at the scene of the accident. She did not stop at the scene of the accident. She did not provide her name and address. She did not exhibit her driver's license. And she did not render to any person, Officer And the final element is that the defendant knew or reasonably should have known that death resulted from the accident. Knew or reasonably should have known. This doesn't happen, ladies and gentlemen, when you hit a sign. The severity of the accident was incredible. It launched a 5'10" man over the roof of a vehicle and 160 feet in the other direction. That doesn't happen when you hit a sign. That happens when you hit a man. That happens when you hit a person. When she hit that man, he went face first into that windshield. Remember the testimony from the medical examiner that when she struck Officer Galinger, he went face first into the windshield. She saw that. She saw that man go face first into her windshield, and she kept driving. His head then went up. Well, his body went up and over while his head was in the windshield and went over the vehicle. That doesn't happen when you hit a sign. That happens when you hit a person. We know that his head was stuck in the windshield because his head is there. Could you get the lights for me, please? Well, that just made it worse. Could you turn off those lights? Because his hair is sitting there. How do you drive 5.2 miles home or 5 miles home and not see his hair lodged there in that gash in the windshield? Of course she knew it. Of course she saw it. How do you not see a piece of the man's scalp on your steering column, staring back at her as she drove home? She should have known that she hit someone based upon that, based upon the severity of the accident, based upon the remnants of that individual that were left on her car and inside her car. But she just kept on going. Next, I'd like to talk to you about vehicular homicide by intoxication. Any person who commits the offense of vehicular homicide by intoxication is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. The defendant killed the alleged victim by the operation of a motor vehicle. Yes. The defendant acted recklessly. What is recklessly? A person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. What is the standard of care? Let's start off by saying she was familiar with that road. When I asked Melissa Hinds if the defendant was familiar with that road, Melissa Hinds said yes, that she knew that road and that she took it as a shortcut to Farm to Fork. She knew the problems that existed on that road. She knew about the manhole cover. She knew about the barrier, and she failed to abide by the standard of care that a reasonable person would know. If you were familiar with that road, just like Mr. Conway testified to during the defendant's case in chief, you know to slow down on that road in those conditions when it's rainy and dark. He indicated that you could see the barriers. This is their own proof. This is their own evidence. He indicated that you shouldn't speed on Hamill Road. That's what Mr. Conway said. She was familiar with that road. We know that because Melissa Hinds said it. She knew that barrier was there. She knew that manhole was there. So what's the difference between her going to Farm to Fork at 6:30, going down that road, going down Hamill Road to meet her family at Farm to Fork? What's the difference between that and her driving by that same area at 11:04 p.m. when she struck and killed Officer Galinger? The difference is she'd been drinking. The difference is she'd been drinking and she was impaired. She knew about the risk. And she continued. And it resulted in the death of Officer Galinger. She acted reckless when she drove down that road after she had been drinking. She acted reckless when she was speeding down that road. That's not the type of road you speed down. That's what Mr. Conway said. She acted reckless when she wasn't maintaining the proper lookout. And she had been warned, not about that specific area just prior to the accident, but she had been warned about a possible accident on her way home. Remember the text from Melissa Hinds to her at shortly before 11 p.m. There's a bad wreck at the split. Cops are everywhere. She had been warned. She says, I got it. I'm past I'm in 153, past it. Shouldn't her senses have been heightened? Shouldn't she have decided, well, no, I need to slow down. I need to slow down. I need to stay in my lane. I need to be on the lookout for other individuals. Yes. She knew the road. She had been warned about a wreck and that there were cops everywhere. And she continued to do what she was doing. And it's because she was impaired. Jared Justice says you could see the barrier as he was approaching it. Jennifer Lockhart said the barrier had been out there for several days. If this is a road that she's familiar with, if this is a road that she frequents, she knows about the barrier. She knows about the barricade. She knows what happens on Hamill Road when it rains. The killing was the proximate result of the driver's intoxication. You will get proximate result means a result which in the natural and continuous sequence is a product of an act occurring or concurring with another, which had it not happened, the result would not have occurred. And you'll get an instruction about cause of death, and it'll give you a little more information about proximate cause. And please read all of this. There are portions, though, that I'm going to point out. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such a case, each of the participating acts or omissions is regarded as proximate cause. It is not a defense that the negligent conduct of the deceased may also have been a proximate cause of the death. That's not a defense. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased or another which the defendant, in the exercise of ordinary care, which we have established that she was not acting in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the exercise of ordinary care the defendant should have reasonably anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. So it's a lot to read. It's not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within the general field of danger which the defendant should have reasonably anticipated. Where is she driving? She is driving down a residential road at night. And I know that at 11 o'clock, more than likely, people are at home. I know that businesses are closed. I know that the church there just past where the crash occurred is closed. I know that the Publix, it probably was closed too. But it is a residential area. In a residential area, people are out. Not necessarily at this time, but certainly it's foreseeable that people are out. And where did this come from? It didn't walk out there by itself. Somebody put it out there. And it's reasonably foreseeable that in a torrential downpour, that someone may need to go fix it. That someone may need to go replace it or put it back up if it comes off because of the overflowing rainwater. Certainly, that's in the field of danger. Certainly, that is something that is reasonably foreseeable. Christopher Dahl, the defense's witness, the guy who likes to photograph sewer overflows, he was out there. Certainly, it's foreseeable that people may be out there. They are in the field of danger. She should know that. It's not I-24 or I-40 running through Nashville. This is Hamill Road, a residential road. Look at Lockhart's video again. When you see her driving to that area, you see residences. You see parked vehicles on the side of the road just before the crash occurs. Isn't it reasonably foreseeable that people might come out to their cars? They might be in their driveways. They might have to cross the road to get somewhere. I know that it's 11 o'clock at night, but when you drive through a residential area, when you drive through a neighborhood, there's always the possibility that someone is going to be out there. The killing was the proximate result of the driver's intoxication. She's had over a 6-pack of beer. Essentially, 76 ounces of beer, a shot of alcohol. Now, a lot's been made about the fact that there are no field sobriety tests. There are no field sobriety tests. No one conducted tests on her which could indicate that she was impaired. Even though she may not be obviously falling down drunk, these tests could indicate whether or not she should be driving a vehicle or whether she's impaired. There are no field sobriety tests. The reason there are no field sobriety tests is because she left the scene. There's no blood test taken that evening because she left the scene. So what we have left with is her erratic driving. And again, she was reckless when she was driving down the road and she was speeding. And it is clear from the proof that she was speeding. You've seen the video of her striking Officer Galinger. You've seen the video of her striking Officer Galinger. It's clear from the video that that Mr. McAlex would put it barreling down the road, barreling down the middle of the road. Justice testified. Jared Justice came here and testified that that vehicle came at a high rate of speed. It was much different than the vehicles that passed by earlier. It was much different than that. They slowed down. They saw the barrier. Master Patrolman Warren testified that he generated, based upon the SIL form, that he was able to determine that she was going between 47 and 53 miles per hour. And Dr. Stephen Cogswell corroborates that. That you would get this injury to your aorta, a transected aorta, or damage to your aorta, when you reach speed, when you were struck by a vehicle that has reached speeds between 45 and 55 miles per hour. So, certainly that is an indication of impairment. Not knowing what your surroundings are, not knowing the speed limit, which was 35 miles per hour, and exceeding the speed limit. Also, can I get the lights, please? I'm sorry. She's in the middle of the road. She's in the middle of the road. That's reckless. You don't drive down a residential road. It's reckless and it's a sign of impairment. You don't drive down the middle of the road in a residential area. She didn't recognize the obstruction in the road. As I've said before, Mr. Justice said that he recognized it. Christopher Dahl recognized it. But she didn't recognize it because she's impaired. I'm sorry that we don't have field sobriety tests. I'm sorry that we don't have a blood test. But that's not through any lack on the state of Tennessee or any knock on the Chattanooga Police Department. It's because she fled. She fled the scene. And isn't that the most significant sign of impairment? Isn't that the most significant sign of impairment? If you get into an accident that does the damage that happened to her vehicle, you stop. You stop. And if you don't stop right away, you pull off to the side of the road, at least to check. At least to check your car to make sure you get home. You don't drive 5 miles with your car looking like that. You stop. Because, and the reason you don't stop is because if you do stop, you have to explain some things. You have to explain why you just hit this person. Why you just hit Officer Galinger. You have to explain how much you've had to drink. And she doesn't want to do that. You have to explain why you have empty Ambien pills in your Ambien bottles in your car. You have to give explanations for all that. You don't drive home with the dead man's hair in your windshield. You don't drive home with the dead man's scalp, a piece of the dead man's scalp inside of your vehicle. But that's what she did. Officer Galinger was there that night performing his duties as a Chattanooga police officer, and he's not just a dead man. He was there to protect the community, and she ended his life through recklessness, intoxication, and disregard. Ladies and gentlemen, everyone has done their job over the past few days. Mr. McGowan has done his job in defending Ms. Hinds. The state has done their job in proving all of these elements of all of these charges beyond reasonable doubt to moral certainty. And the judge will shortly do his job as he has done over the past few days, and he'll instruct you on the law. And after that, it'll be your turn. Ladies and gentlemen of the jury, go back there, look at the evidence, look at the law, and do your duty and find her guilty of vehicular homicide by intoxication, leaving from the scene of the accident, and the other charges that she has been indicted for. Thank you very much.
Thank you, Judge. Sometimes it feels like in this country that we are living in a post-accountability age, that we have somehow lost the notion of personal responsibility, that we have adopted the idea that if we can point the finger long enough and strong enough at somebody else when something bad happens, that somehow people simply won't pay attention to what we did to bring about that, to cause, to contribute, to create the problems that led up to it. Now, that may seem, you may feel like that's ironic coming from a defense lawyer talking about accountability, but this courthouse is a little different, because what we have here is a system that is predicated on the notion that the state, with all the power that it possesses, is under the obligation to put forward evidence, and to put forward evidence beyond a reasonable doubt to convince you of what they are claiming before they can subject somebody to punishment, before they can take away somebody's freedom. So, in ancient Israel, they had there was a religious ceremony, an annual religious ceremony, where the community would come together and they would select two animals, and one animal would be slaughtered and sacrificed to God, and the other animal would be symbolically invested with all the sins from the year of the community. And that animal then would be taken by the priest up to the highest cliff in the area and tossed off into the abyss. That's where we get the term scapegoat from. The one who is sacrificed for the sins of others. Ladies and gentlemen, you have been very diligent in listening to this case, and there's a lot of information to go through. I want to begin with the notion that this is a tragedy, that what happened to this officer is very, very sad. He was doing his job. And in my experience, at least, the police are people. They're people just like us, but they're people who generally act with integrity. They've come to that profession for a reason, because they want to serve, because they want to take care, because they are good people. So anybody who would set out to target the police, to intentionally cause harm to a police officer, let hellfire rain down on them. Because they're not just attacking that individual, they are attacking the entire community. But what about when that person, that police officer, could have been anybody? Could have been you, could have been me in that road that night. The idea that we are going to build a prosecution that is so tenuous, that is so weak in its regards because of who the victim is frankly fundamentally unfair. And that's what we're looking at here today. We're looking at a case that was created and brought about because of the status of the individual involved. And how do we know that? So you have, in this case, Officer Joe Warren. Ladies and gentlemen, you heard from Joe Warren at length. He loves his job. Obviously, he loves the police. There's no question about it. He's an advocate for the police. He was the one who was going to lead this case to justice. He was going to nail a cop killer. That's effectively what was going on. The problem there is that he was the investigator. He was the one whose job it was to compile the evidence that you would need to figure out the truth of what really happened that night. I submit to you that he had trouble being truthful even here in a court of law in front of you. So what was happening in the dark of night in his office when he was working on this case? You don't know because he didn't collect it. He didn't make reports. He didn't talk to witnesses. He did not conduct this in any way that someone truly hoping to find the facts would have gone about doing it. The manuals, the training books he used, even our own common sense and experience tells us that we don't arrive at the conclusion we want to reach and then we find the facts to support it. That is confirmation bias. But we have something worse here. We have actual bias. We have somebody who was willing to sidestep the routine procedure because he had put himself out on Facebook as the one who was going to vindicate the rights of Nicholas, as he said. That is the foundation upon which this investigation is built. What did he cover up? We don't know. What did he not pursue? We don't know. Those things are important. The defendant can't collect evidence at the scene. The defendant doesn't have the resources to locate those kind of things. If there are facts that are not delivered to you, and in this case I would say intentionally so because Joe Warren is certainly not lazy. Joe Warren is certainly not inexperienced. So what was the third option? The third option I offered him was somebody doesn't do an investigation because they are worried where it will lead. Because they are worried about what they might find. Ladies and gentlemen, I will not pretend to understand the voodoo mathematical formula that Joe Warren brought to you to explain the speeds in this case. But I will tell you, I submit to you, if you don't think for a minute that a guy who can't be honest with you from the stand also is not going to tweak those figures in just such a way that it is as bad as possible in terms of speed for this woman. What's the other evidence of speed? The other evidence of speed is, quite frankly, Dr. Cogswell. So Dr. Cogswell testified, well, it could be consistent with a speed of that. And specifically, he mentioned the aorta. And that was a sign that the speed could have been. What else did he mention? He mentioned there had been surgery to that aorta. There had been a prior repair. Quite frankly, the idea that there may have been a fundamental weakness in that aorta that could result in that, if that is even a valid strategy, a valid way of coming up with speed, because I have never heard, in my experience, of speed being estimated within 10 miles per hour on the basis of someone's injuries. But Dr. Cogswell seemed like a nice guy. He seemed like a state's witness, and he seemed like a witness who has, for his entire life, worked for the state and testified in criminal prosecutions for the state. And he seemed also willing to go outside of his expertise to try to help the state. But I leave that to you. The third piece of evidence we have about speed is Jared Justice. And Jared Justice's testimony that the car was going faster than the other cars in the area. Very fast, I believe you might have said. Well, what is the key piece of evidence that you have in your possession? Because, quite frankly, everything you need to resolve this case is right here and right here in your minds. Because you have paid attention to the facts. You have a video from the seconds after the incident in which Jared Justice is claiming stop that car, and he's saying, in 3 instances, just what happened. And he mentions the car is over the line, which, by the way, incidentally, you show you a photograph here. This has been marked in evidence. This is the body camera from Officer Galinger just moments before he's killed. You'll notice he's in he is in Janet's lane of travel. Whether the defendant was in the middle of the road, which I would submit to you is not a sign of bad driving, it's a sign of good driving. When you watch Officer Lockhart's video, pay close attention. Where much of the time is she driving down that road? She is driving with her wheel over the center line, her driver's side tires over the center line. That is because that is a narrow road. It was rainy that night. There is a guardrail on the side. There are cars parked on the side. That is the safest way to go, particularly when you get to the straightaway and you can see whether there are any cars in the distance. But in any event, I would say that the idea that the idea that her not being in her lane of travel somehow contributed to his death is simply not factually correct. Jared Justice said other things. Jared Justice had come before you, and I am compassionate for Jared Justice, but I will tell you, my compassion begins to wane, and it ends when somebody will come in here and insult the intelligence of this jury by suggesting that they didn't put on their blue lights because that's distracting. And when Officer Warren would come in here and say, oh, by the way, I agree with that decision. It's distracting to put on blue lights. I don't know about you, but if you've ever seen a car pulled over on the side of the road by a police officer, what do they have on? So they put on the blue lights to stop them. Do they turn them off then? No. Okay? What is the first thing that Jared Justice did when he pulled the car out into the road after Officer Galinger was killed? He put on his blue lights. Jennifer Lockhart's video shows you very clearly what would have happened that night if FTO Justice had put on his lights. From before Jennifer Lockhart, Officer Lockhart is even out of the curves, you can see those blue lights. You can see the brake lights and you can see the blue lights. It is about staying safe. Ladies and gentlemen, you know, the idea here that this is about foreseeability. It's about whether if the defendant is to be blamed for this, and we're to find that her actions, I think the state had specifically referenced the recklessness instruction. Reckless homicide. I'm going to ask you to look at that recklessness section. It means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. Okay? Was it a substantial risk that there would be someone standing in that road that night? Was it a substantial risk that someone standing in that road that night would be wearing all black? Was it a substantial risk further that person in the road that night wearing all black with no reflective equipment would be leaning over to pick up something behind a barrier? Ladies and gentlemen, the state would have you believe that this is about whether she saw the barrier and whether she hit the barrier. No. It's about whether she had reason to believe that there would be a person concealed in the road at that time. So, ladies and gentlemen, quite frankly, we submit that there is absolutely no reliable proof of intoxication in this case. You heard from a state's witness. The state would have you believe that this is being prosecuted like everything else. But what did you hear from a very persuasive witness from the Tennessee Bureau of Investigation crime line, the toxicologist? I believe his name is Little, Director Little. He said, "This is the first time I've ever been asked to make calculations like this without blood and come into court and testify about it." Do you recall that? So what he is saying is that what is being asked of him has never in his 30 years of experience been done by him. This is not a typical prosecution. Ladies and gentlemen, the evidence of intoxication, such as it is, was seen with your own eyes. I think the scientific proof is that there are a variety of variables that can be plugged in that are perfectly supported by the science, which would lead to there not being a result of over 0.08. Because I don't want to confuse the issue. When we're talking about over 0.08, we are talking about shorthand for an issue which is not truly in this case, which is that this is not a DUI per se. This has to be a DUI where impairment is caused by alcohol consumption. But what we have is proof that she is well within she's in perfect control of her faculties at the restaurant. The people who are with her, who were never spoken to by the police, even when they reached out, like Tracy Phillips, would say then, as they said now, no, she was absolutely okay. And we know it. We've seen her when she's been drinking. Ladies and gentlemen, that's not information that the state wanted to have, but thankfully for all of us, that was on video for you to see. Now, I'll be truthful with you. It's a little terrifying to me that we live in an age where everything we do is being videotaped. We're being watched at all times. And if something tragic should happen, God forbid, an accident should happen, and the person that you should happen to kill is important enough, you better hope that you've taken all your recycling Ambien bottles out of your car. You better hope that you don't yawn in the restaurant. You better hope that you don't hug your son too heartily, because those innocent things will be used to make you look like a criminal. And that's effectively what has happened here. This is a tragic accident. There are civil remedies for accidents. In fact, a $25 million lawsuit is ongoing in this case. And that's where this should have stayed. I think you have to ask yourselves, had this happened to you or me, where if we had stopped as a good Samaritan and walked out into the road and picked up that sign and been dressed in clothing that concealed us against the night, and we had been hit, do you think anybody would be sitting here today? No. What would have happened is that people would have said, you know what, that's really sad, but that person should have been more careful. That person should have known better. That person should have taken care of themselves. So if we're talking about a superseding cause, we're not talking about the mere negligence of Officer Justice, whose responsibility it was, mind you, to look after his field trainee. But he can't admit that to you even now. He can't say that he should have turned his lights on. He can't say that they should have put their reflective gear on. It strains credibility that somebody could come in and say that those weren't causes here. And we're not talking about mere negligence. What we are talking about in an instance like that is what is called a superseding cause. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased or another which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. These things are fact dependent. Okay? If someone is speeding down the road in a residential neighborhood and the houses are close to the side of the street and a child runs after a ball and is hit, sure, that's pretty foreseeable. that seems like a real risk. But what we have to measure here is the exact facts and circumstances of what went on there. And I described this at the beginning of the case as a perfect storm of misfortune, of things coming together that were, frankly, tragic and dangerous, and the result was awful. But ladies and gentlemen, you've seen that crime scene in the videos. You've seen what it looked like. If ever there was a crime scene that more begged out for a reconstruction, a physical reconstruction, it was this one. Because though Officer Warren would have you believe, oh, this was simple, this was cut and dry, this was straightforward, this is one of the most complicated crime scenes I can imagine. You have rain, you have glare, you have lights, you have an inoperative barrier, you have pedestrians in black, you have water that is both coming down, you have a defendant who is almost 60 years old, who wears glasses that you have in evidence that you will see were badly scratched, which contributes to glare. You have pools of water that are moving. So we have light shining down from above onto pools of water that are moving, that create a glare in of themselves. We have a shoddy, rickety old barrier. And again, remember, this is not about hitting the barrier. This is about whether one would reasonably expect that there is a person concealed behind that barrier. Would that be evidence that would be helpful for you in making a decision? If Officer Warren had reconstructed that scene, not driven there in the middle of the day, on a sunny day, why do you think he chose that day to do it? We've had rain all week. No, he drove there on a sunny day to show you just what it looked like driving out there at 2 different speeds. No. What should have happened is that they should have placed a mannequin behind the barrier, dressed in black, and they should have driven up to that scene at various speeds and videotaped it so you could see just when that barrier became apparent. And more importantly, if the mannequin dressed in black behind that barrier ever became visible. Mr. Williams has said that of course she knew. Of course she knew. There was a face in her windscreen. That was not the testimony. But the testimony was that she hit the barrier, which is the last thing conceivably she would have seen. When you hit something that comes up in the window, what do? I don't know about you, but I close my eyes, I blink. And we're talking about a car traveling at a minimum at 35 miles an hour. That's 51 feet per second. So we are talking about a near simultaneous impact of the barricade and the officer. And then we are talking about, and this is Joe Warren's testimony. We're not talking about her driving with somebody's face sticking in that windshield. Mr. Williams referred to it as stuck in the windshield. Nonsense. The reason Joe Warren did not ask, or well, what he claimed the reason he didn't ask Jared Justice about what happened and the angle of launch, you'll recall I asked him, that would have been information important to your calculations if you knew the angle of launch. And he said, no, it happened too fast. He couldn't have seen that because it happened too suddenly. You have a situation here where the defendant left the scene. And so you have to make a determination because those charges that she's facing are dependent on her being aware that she had hit someone. Look at the video. Look at how visible those officers are, even in the scene afterwards. Play that video if you would. I'm sorry? Okay, thank you. I'm trying to be respectful of your time. Yes, could you switch to the defendant laptop, please? Thanks, Judge. Watch the videos yourselves. You tell me when the officers become visible. Where's the officer now? Oh, there he is. You can see him because he's walking in front of some lights. Throughout these videos, what you see when you watch them is people appearing out of nowhere, or so it would seem. Granted, that's the best we have because Joe Warren did not recreate the scene. What we have is all the police lights and everything else. But quite frankly, what we're dealing with, look at the reflection off that water. We had a light shining down directly on top of the water. Now, the state would have you believe that everyone, that she must have been impaired because everybody else saw the barrier. What did Mr. Conway think? I would say he was a disinterested witness. He came in today, seemed like a perfectly nice guy. He said, that's a bad road to speed on, and I would tend to agree. And he said, when we drove by that barrier at 7 p.m., it wasn't there. We didn't see it. If the state would have you believe that first of all, they use the term she's familiar with that road. I don't know quite what that means. I'm familiar with a lot of roads in Nashville. That doesn't mean I ride on them very often. But if the state is trying to imply that she went by that area earlier in the evening and would have seen that barrier, or that she knew about this regular flooding, that is not supported by the evidence. What is supported by the evidence is that there was no barrier there at 7 p.m. So this idea that that barrier had been in place and been successfully avoided by all these passers-by is just not accurate. We don't know whether the person who called in that barrier called it in because this sign was in the road or because they almost hit that barrier. That is not the defendant's fault that you don't have that evidence. It is the state's fault. It is the prosecution's fault because the police and the prosecutors are hand in hand here. I would say particularly so in this case. Would it be helpful to know what brought the police to the scene that night? That's for you to decide. But it's only for them to provide. How are we doing on time? She fled the scene. She knew she had hit a person and she fled the scene. So you know what she did? She drove to her house. She parked her car right in front of her garage. She left it out there in the open. She called her daughter-in-law. Now, she's a terrific criminal, isn't she? This is a genius plan for concealing herself. And she spends the night there. Ladies and gentlemen, you know, Melissa testified that she couldn't pull into the garage. You saw the bags of soil in front of that car, in front of the garage. Do you think that somebody who was trying to hide themselves wouldn't have any trouble moving those bags and putting their car in a garage? You think that that car could not have been left somewhere else if that is in fact what she was trying to do? No. She woke up, and I would submit that her reaction when she found out about this the next morning tells you all you need to know. The state can't seem to make up their mind about whether she's a master criminal or she was so wasted that she didn't know what she had done. But I would submit to you that we had a credible witness in the person of Melissa Hinds who came in and said, when I told her she had a go to pieces. That this is somebody who wears her feelings on her sleeve, cannot conceal stuff, would not have been able to pull off some ruse of calling that night and saying I hit a sign if in fact she had hit a person. Because the next morning when she did learn, she became a puddle. That does not sound to me like somebody who is trying to get away. Nor does the fact that the first thing they do is start contacting lawyers. Nor does the fact that the next thing they do is have their lawyer contact the police about turning them in. And then what does she do? Master criminal that she is. She goes to the police station, turns herself in the next morning. This whole notion that she fled from the scene doesn't stand up to the evidence. This whole notion that she drove quickly away from the accident site so as to escape doesn't make any sense. What do you see in that video? When you watch Jared Justice's video, after he runs and begins to attend to the dying officer, he turns around and runs back to his car, mind you, to put his blue lights on, block the road. And as he is running back, you are seeing, coming from the direction of 153, two headlights at a high rate of speed. It is, in fact, the car that Jared Justice needs to flag down and tell to slow down and then to stop. That is the car immediately behind the defendant. The car that the police never bothered to try to find, or at least didn't until we asked them to try to find it. So we said, where is this evidence? Because I can't imagine a competent investigator who, when he's told 3 times by the percipient witness on the scene that that car may have been involved, would not get those people's names and find out what they had to say. But Mr. Warren was not trying to find those facts. But these people came right up on it. And what could they tell you about what the defendant did? You don't know, right? You're going to hold that fact against her when she was not in control of this investigation, or are you going to hold it against the people who have the burden to prove to you beyond a reasonable doubt what she did? She drove away from that scene because there was a car hauling it behind her up that road. She drove home with a broken windshield, and the windshield was a mess. Everybody can agree on that, right? She drove home. Okay, this is by testimony of the witnesses, a stubborn, independent, 55-year-old postmaster who is probably a little embarrassed that she hit a sign and is 5 miles, less than 5 miles, I think Officer Warren said 4 to 5 miles from her house. And yeah, she drove home. Was that the best idea? I don't know. I am not a 55-year-old woman. I am not on a dark road in the middle of Dixon. They want to say, well, there are all these other places they can stop. Look at where these places they talked about they can stop. Accident happens here. And we're talking about businesses up here. She's halfway home by that point. It's not proof of guilt. It's not proof of anything other than the fact that you have an independently minded person who doesn't feel safe stopping in the middle of the road. Stopping on the way back to their house when they were so close to home. Mr. How are we doing? Fine? Almost out. Okay. All right. I want to go over a few points. Mr. Dahl. Okay. So look, Mr. Dahl, who they want to characterize as a defense witness. Mr. Dahl, believe me, I would not have chosen Mr. Dahl to be involved in this case had I had a choice. But what happened was, when you get people who, as a hobby, like to take pictures of sewer water, sometimes they're maybe not exactly what you'd hope to have as a witness at trial. But that's not the important thing. The important thing here is that he was there. That he was there minutes before. And whether he's a quirky odd duck or not doesn't change that fact. There is no allegation that he fabricated those photos, nor is there any allegation that he didn't send them to the police and offer to meet with the police and talk with them. And if the police wanted to find out what happened, and they have a witness from minutes before, that's the person they would contact. Now, his account now, it's a mess. But what was his account back then? In the days and hours after this incident happened? That is information that should have been collected by the state. That is why the policy manual says, get witness interviews and get them right away, record them or write them down. Look, even Mr. Dahl said, and I'm not sure Mr. Dahl's judgment is totally above board, but even Mr. Dahl said, I wouldn't have walked out in that road and picked up that sign. I thought about it. There's traffic on that road, and that's dangerous. I think part of the tragedy of this case is that we had a very not young, but a very inexperienced officer, very new to the job. And sometimes what can happen is that when people become police officers, there's a bit of feeling of invincibility. That you've got that uniform, you've got that badge, you've got that gun belt, and you are ready to go save the world. And I am not putting this officer down. What I am saying is that there is a reason that there is a field training officer. There is a reason there is a 4-stage program. The first 4 weeks are just look and listen. The basic stuff, basic safety, is because people come out of the academy and sometimes they are ready to go. and they feel somewhat invincible. I'm going to leave it with you because I can in no way cover the information that you all have. You can discuss this, but I want to leave you with one thought. The prosecution wants us to believe that she should have seen the officer, and that the fact that she didn't see that officer in the road was a sign that she was impaired. They haven't asked you about why the officer standing in the road couldn't see her. He wasn't impaired. Now, what's good for the goose is good for the gander. And what that means is that when they want to hold her to a higher standard than the person that they are trying to vindicate, a person whose death they do not want to have be in vain, they don't want their brother officer to have died for nothing. And in their minds, that means, as police officers, we need to get a conviction. And sadly for us, that means that Janet Hinds will be the sacrificial lamb. She will be the scapegoat. She'll be the scapegoat for the sins of the Public Works Department. She will be the scapegoat for the sins of the police department. And I am asking you to look at this evidence, this very weak evidence that has been put before you, and to come back and to not throw this woman into the abyss. Mr. Pinkston is going to get up and he's going to give you a very emotional, he's a powerful orator, and he's going to finish it out here, and I won't have another chance to speak with you. But I will ask you now to look hard at this evidence, because this is about not an average, as the scientists would have it. It's not about the amalgamation of a few people all divided. No, this is about an individual and an individual's life. And punishing someone for an accident will do nothing to bring back this poor officer whose life was lost. Thank you.
Mr. Pinkston, you may closer.
I must say that's quite melodramatic, even for a criminal defense lawyer to make.
I'm going to object.
I will sustain those two. Move on.
Judge, he's been given free liberty to accuse people of everything for the entire week.
Well,
And you've allowed him to do that.
Just argue your case. That's fine.
All right. It's ironic to me that Mr. McGowan spends his whole time talking about. I guess his claim is that Ms. Hinds, the defendant, is a sacrificial lamb at the hands of the police department, the district attorney's office, the public works department, and everyone else. And yet, he spends, when your client has consumed a six-pack of beer and taken a vodka shot and sped, and he says there's no evidence. Something about no evidence of bad driving or reckless driving. Look at State's Exhibit 14. She's over the double yellow line. Easily. That's clear, convincing proof beyond a reasonable doubt of reckless driving, without a question. Nobody, Mr. McGowan is the only one that said that driving down the center of the road is safe. Those were his words, and again, that's not evidence. Mr. Conway said his wife stayed in her lane of travel. She wasn't drinking below the speed limit. Now, the one thing Mr. McGowan said that Mr. Conway said it wasn't there, he told me he didn't remember if it was there. Those are two drastically different things. So if whatever is good for the goose and the gander, or if we're going to point the fingers at others and we're trying to find the truth, then why is Mr. McGowan misrepresenting what a witness testified to? Why would you do that? He said, I don't remember. That is far different than saying it wasn't there. And then he claims that the defendant's daughter-in-law is a credible witness. And she said, oh, you know, she was fine. Her mother says that the defendant was fine. The farm to fork people said that she was fine. Well, of course they're going to say that. Because as Mr. McGowan is taking great lengths about bias, think about bias from the defendant's daughter-in-law. Defendant's former sister-in-law, apparently, if I understood the family tree as she was testifying, and think about what the farm to fork's worried about. This isn't about a civil remedies. The civil lawsuit has nothing to do with why we're here today. The reason why we're here today, the reason that end of watch for badge 1016 occurred on February 23rd, 2019, is because of the decisions and the actions of the defendant. Now, we can point fingers at everybody else, but don't be confused and don't let it be lost in all of that. She is the one that decided to go see a band, and she's the one that decided to drink a six-pack and take a vodka shot. That's her. Nobody forced her to do that. Within less than 45 minutes of the crash, she downs her last beer. That's her decision. Now, if Miss Melissa Hinds thought that her mother-in-law was okay to drive, then why on earth would she tell her that police are everywhere? Why would that even matter? If she's fine to drive, what's the concern? Well, the concern was they know she'd been drinking. And, well, not just that, she's a party animal. She's a terrible driver. She has bad eyesight. And then Mr. McGowan wants you to look at some pair of glasses and see the scratches on them. We have no idea when the scratches got on these glasses. We have no idea when that occurred. And so, if it's late at night on this dark road, and you've been drinking and you have bad eyesight and all these things, then why are you speeding down the middle of the road? And why don't you brake? Normal people, when they hit something like that, brake. She just kept on barreling down the way. And she stops. You can see in Justice's body cam, she stops for a moment. And you could even see it in the ministry center that she stops for a moment. Then she takes off. Why did she take off? It's very simple. She's been doing this. And she's been taking a shot and drinking more beer. Not much food. That's what this case is about. And Officer Galinger had every right to be in the roadway to check this hazard. He's a police officer. He was dispatched out to check on a possible hazard about possibly closing a roadway. That's his job. He's allowed to be in the road. She's not allowed to run him over and just keep on going. That's not that. Let's be frank here. That's what the case is about. He's allowed to do his job. He was doing it, serving his community. She was out drinking and driving recklessly, speeding. If Joe Warren is so incapable of this, that, or the other, then how come the range of speed he comes to is very close and equivalent to that of Dr. Cogswell? Dr. Cogswell says she's going between 45 and 55 miles an hour. Gerald Justice says she never hit her brakes. She keeps going. Why does she keep going? Well, I would submit it's pretty clear why she kept going. Because she had pounded down a six-pack and a liquor shot within the 3.5 hours before she ran over and killed Officer Galinger. And she had empty pill bottles, and she didn't want to answer for any of that. That's why she left. Now, there's some, again, about finding the truth and getting to the truth of the matter. Mr. McGowan, in his closing, said she had to be aware to be guilty in this leaving the scene of the accident. That's not what the judges and jury instructions say. It could be either that she knew or she reasonably should have known. It's an or there. He said it's absolute. Well, why is he misleading you when you're going to get the law? I guess, speaking of insult to individuals, why would he do that? Because he doesn't want you to focus on what she did. Now, again, we've had this up and down about falling down drunk, she looked fine to me, things of that nature. And again, just follow the law. What does it say? And I put those stars there. That's my... Under the influence covers not only all the well-known and easily recognized conditions and degrees of intoxication, goes on to say it deprives the driver of that clearness of mind and control of oneself which the driver would otherwise possess. In this situation, it would not be necessary that the person be in such a condition that would make her guilty of public drunkenness. You talk about the video at Farm to Fork. Well, we don't have to prove that she's fallen down publicly drunk. The law doesn't mandate that we do that. It requires that the person be under the influence of an intoxicant, and the intoxication may be such that it impairs the driver's ability to safely operate a motor vehicle by depriving the driver of clearness of mind and control of herself, which she would otherwise possess. So we know alcohol is an intoxicant. How did the six-pack and the shot deprive her of clearness of mind and control of herself? Well, again, this lady who's a party animal, who's a terrible driver, apparently can't see well at night. Okay, and then she adds on top of that, she's been drinking for 3 or 4 hours. And so then she gets in her car with police everywhere, and this is how she operates her car. Driving in the other lane of travel, straddling the double yellow line, failing to maintain control of her vehicle, failing to exercise due care. There's nothing in this photograph but recklessness, failure to exercise due care, speeding. It's all right here. And that's the defendant's actions. It's not Officer Galinger's fault, or it's not Public Works' fault because they didn't put a sign up under the manual for uniform traffic control devices. I would submit to you easily, if you do this for 3 or 4 hours and you drive in this manner right here, where you almost totally dissect an individual's aorta, and if you remember, Dr. Cogswell also said the surgery that he had was one of the stronger parts. That was conveniently left out. But I would submit to you, if you drink and you behave like this, it doesn't matter what the sign looks like. You could be flashing lights, it could be all kinds of stuff. She's still going to hit it. She's still going to nail it. I mean, there's all the signage in the world didn't stop her from drinking and driving. If there was a wreck at the Split and police were everywhere, that didn't stop her from continuing to barrel down Hamill Road, and leave Nicholas Scott Galinger laying in the street. No sign would have stopped that. How should she have reasonably known that she hit or killed somebody? Pretty much, as Mr. Williams said, human tissue and hair in the windshield. How in the world did she drive home? Well, maybe she stuck her head out the driver's side window and drove home. I have no idea how she drove home. But yeah, that's the largest sign of impairment. And the part about driving home and not pulling into the garage is because she's impaired. She doesn't possess the clearness of mind, and she doesn't possess control of herself. That's what this case is about. Now, and there's some... and let's be clear here too. Mr. Dahl, interesting witness. Okay. Mr. Dahl he has an axe to grind about sewage apparently. But when you listen to him, this is the picture he took. Look how well lit that is. And what did Miss Carr from EPB, the Electric Power Board, talk about? It's a 27 feet up the light. It projects downward and outward. Essentially 36 yards on either side of the pole, about 25 yards forward, which would be across the street, because we know, according to Joe Warren, both of the lanes are about, give or take, about 11 feet wide. So light all the way across the street, 75 yards, almost a total football field, and about 16 yards back. And Justice's car was there, and the headlights were on. Mr. Dahl is just mistaken about that. But the other thing is he has the defendant passing him seconds before the accident occurred. And that's just not a witness, because the only metadata of his photos show that it was taken 3 minutes before the accident happened. And he said that he was getting in his car after that picture and went on his way. He wasn't a witness to what happened. He wasn't a witness at all. He's a witness to show you that the streets lit up. And we all know, everybody knows that drives this road, that this can become a water hazard. Everybody knows that. That's why her familiarity with this road is very important. And her daughter-in-law said it. She said the way from her house to Farm to Fork, or from Farm to Fork back to her house, you take Hamel Road. So if you take that earlier in the evening, you get down there at roughly 6:43, 6:45, and you take Hamel Road, you pass right past this. On your way to Farm to Fork, coming this way, the same things right there. Now, granted, it was evening at that time, not as late at night, but look how well lit that is. And I submit to you, Exhibit 13, Joe Warren talked about it. Coming out of the curve into a straightaway towards the manhole cover is approximately 550 feet. Or if you convert that to yardage, it's about 183 yards. That's almost 2 entire football fields of distance that she had to see if she were maintaining due care, not speeding, not driving recklessly, not being impaired. She would have easily been able to deal with that. Nicholas Galinger is not the cause of his death. He's not an intervening cause. He had every right to be there. If she was in full possession of her faculties and not impaired, not full of a 6-pack of beer and a vodka shot, this would have never happened. Would have never, ever happened. And the reason why she eventually turned herself in, well, that's pretty easy. She's on TBI's top 10 most wanted. I mean, that's not very difficult to figure that out. And so it comes down to it. Blame the sins of others, I guess. I'm not sure necessarily whose sins, but I guess anybody that's involved in this prosecution or investigation, it's our sins. But merely, and not merely, but what did Joe Warren also know about this particular scene? You only see it generally you only see a pedestrian thrown that far on interstates. And the reason why is the speed. She threw him over 160 feet. That's because she was speeding. That's because all that force of that vehicle that wasn't braking, because remember, Dr. Cogswell talked about where it struck. The car wasn't dipping as it was braking. She never brakes and throws him over 160 feet because she's speeding and she's under the influence. That's what this case is about. And we have provided that proof to you beyond a reasonable doubt. And so this week and last week, we talked about this presumption of innocence. And as the defendant sat there last week and this week of the trial with this cloak of innocence, witness by witness, picture by picture, that cloak is removed, and all that's left to see upon her is guilt. Guilt of killing Nicholas Galinger, a vehicular homicide by intoxication, leaving the scene of the accident, and all those other related charges. That's what remains. The cloak of innocence is gone. She's guilty. She is the reason the end of watch for badge 1016 occurred on February 23rd of 2019. Now, you all have a duty as well, and I will leave you with this. When you are provided proof beyond a reasonable doubt of someone, as we have with Ms. Hinds, then under the law, it is your duty to convict her. And that's what we are asking you to do, is to convict her as charged of all these counts for the vehicular homicide death of Officer Galinger by intoxication, leaving the scene, and all other related charges. And it's not about everybody else. It's about her decisions and actions on that night. And that's why we're here. That's why we're here. And I will also submit to you, if it were anybody else, we would be here too, under these same facts. If somebody was at a bar and were drinking and driving on the wrong side of the road and speeding and fleeing and killing somebody, it doesn't matter who you are. You should be held accountable for that. It doesn't matter who the victim was or what his job was. It matters because he had a right to be there and to do his job. But to say that we're prosecuting it because he's a police officer, we would prosecute under these facts anybody who was a victim. We don't look at justice that way. We don't look at justice that way. We have a duty. And we've presented you with proof of the guilt of the defendant on all these charges, and you need to convict her as such.
Can we pray briefly?
All right, closing arguments have concluded in the state of Tennessee. We just heard first from the state. Then the defense attorney got his opportunity, and the final word comes from the state by the rebuttal that was just offered.